Hi, this is David Cook, and I am following up. This is a two-part series, and the first part was about covenants not to compete. This second part of our series, I'm going to talk a little bit about some other ways that you can restrict employees and independent contractors from leaving your business and taking your clients and hurting your business. Now, outside of doing a covenant not to compete, where you restrict their ability to work at all in any industry that you're in, these are some ways that you can restrict them from doing other things that are not quite so invasive, and courts like these a little bit more. The courts don't like to force someone to be restricted from working in their chosen profession, but they do agree that it's very important to not let someone leave and take all the business with them. So the first of these types of instruments is called a non-solicitation agreement. A non-solicitation agreement is where that employer or that independent contractor agrees not to solicit your customers. This can be very helpful. Now again, just like a covenant not to compete, it's got to be reasonable, and so it has to have some time restrictions. It can't be forever in perpetuity. So you're going to need to talk to your attorney to make sure that you're writing something that is reasonable and will be upheld by a court. But those can be very effective. You're also going to want to have them sign a confidentiality and non-disclosure agreement, which basically says that they're not going to take any of your confidential information, your trade secrets, your customer lists, your pricing data or information, and use it against you. So they can't take all that information and start up a competing business or work for a competing business where they're going to try to use that to your detriment. Finally, you may want to also have them sign what's called a non-disparagement agreement. You don't want them to leave your business and start to say all sorts of bad things about your business to those in your industry, to your former clients, those kind of things. And so this would help prevent that. Now, all of these are much more enforceable than a covenant not to compete. Again, because they don't, they're not as restrictive, essentially, as a covenant not to compete. So we encourage, in all instances, for an employer to have at least these types of restraints. And then if you feel that it's necessary to have a covenant not to compete, we can certainly draft that in as well. If you have any questions about these issues or any other business law issues, we'd be happy to help here at Cook & Gore. Our phone number is 214-236-2712.